Hello, I'm giving an overview of the contract. This is the standard contract used for DC and Montgomery counties. The Maryland contract is very similar, but of course, every state is slightly different. So we've got date and buyer and seller names here, the listing company name and the buyer's agent's company name, and that, I represent the buyer. We put the property address and as much information we can as the legal identification or the tax ID number, things like that. Wherever you are, whether you're in Montgomery County or DC or Prince George's County or Anne Arundel County, because this form is a standard form for the state, then there is also a jurisdictional addendum needed for that county. And then here you're stating the financing for the property. Are you doing, if you're doing a cash deal, then it's 100%, right? You're putting the full amount. But maybe you're doing a 5% down payment, then you're financing 95% as your first trust. If you are using a home purchase assistance program, most likely, then you're also getting a second trust that helps you with that down payment amount, your total financing, and then here's your purchase price. And then here's what is this first deed going to be? So for most people, we're going to check here, will obtain. And it's going to be a fixed loan, and then what type of loan it is. And the second deed of trust, again, same information there. If you are a veteran, you can potentially assume another veteran's loan, and that could very well be very attractive to do that right now. Here is the deposit, your earnest money deposit, will go to whatever the title company is here. And the amount, actually this is the amount here, sorry, the title company here. We're going to check that you will deliver within a certain number of days. And the deposit will be placed in escrow. The account may be interest bearing or not. Usually it's not until after a certain number of days. And seller and buyer agree, escrow agent will have no liability to any party on account of disbursement of the deposit, and except in the event of the escrow agent's gross negligence. Funds due at settlement, the balance of the funds due at settlement will be paid the day or two before. Buyer and seller will verify with settlement agent how those funds will be dispersed. You will receive by law, you must receive no less than 3 days before settlement a final accounting of how much you have to bring to the table. Seller and buyer will perform in accordance with the terms of this contract on, here's your settlement date, except otherwise provided. Buyer selects the name of the title company to conduct the settlement. Property maintenance. So what condition is this property going to be in and on what day? Unless otherwise specified, the seller will deliver the property at settlement vacant, free, and clear of trash and debris, broom clean, and in substantially the same physical condition to be determined as of the date of offer or the date of inspection or some other date. So for most people, we're going to say the date of inspection because that's later. We're doing the inspection after we're under contract. If we've done a pre-inspection because we're in a competitive bid and we want to remove the home inspection contingency, then our latest date really is the date of offer. So we want to state that. And here we're indicating that it is or is not contingent upon a home inspection. If it is, then we attach an addendum that covers that. The seller will give us access for inspections and for a final walkthrough, but anything other than that, the seller does not have to give us permission to get in and may or may not do so. The property will have a list of things that are included or excluded. Again, that's another addendum attached to the contract. Though in the Maryland contract, it's specified in this piece of the contract. It is not a separate addendum. If we're getting a home warranty, I usually do this only if we're going to ask the seller to pay for the home warranty. Otherwise, I generally check no, because at the date of offer, we don't know. You might want to buy one later or not. You know, you haven't really thought about it. It's not yet an important decision. So this can be changed later. But if we are asking the seller to provide it as part of the contract, then we should check this here. Here you're representing that you will or will not occupy as your primary residence, and then you're authorizing us to discuss with the appropriate financial and other places so that you can get verified and get your loan. If there are termites or maybe a termite inspection that's required based on your lender, or whether it's something that you want to do, this is saying that any repairs will be made at the seller's expense. Okay, if we are looking at a property that was built before 1978, there is likely to be lead paint in there, and there are federal forms and there are state forms. So that's what all of this refers to. There's also like a pamphlet that tells you how to deal with lead in the home and protecting your family from lead paint, and we have to give you that. So that's basically what all of this is saying. And so we're going to check yes. If it's after 1978, then we're going to say not appropriate, but we still have to initial all these things. Financing is contingent. If this deal is contingent on financing, the buyer will make that application no later than 7 days after the date of ratification. So this is giving you the opportunity to change your financing, different from what was spelled out in the upper part of the contract. And it also deals with then the provisions of the default. Seller agrees to comply with reasonable lender requirements except as otherwise provided in lender required repairs paragraph, and that's in a separate addendum. If there is any damage to the property or loss, it is the seller's responsibility until the day of settlement. The title company is going to do a background check and make sure there are no liens, the title is clear, and all that sort of stuff. If there are any clouds or things found, then it is the seller's responsibility. The seller shall promptly take all action necessary to place the title in required condition. Possession date is usually the day of settlement, and so buyer's legal fees, other property paid by the buyer. This is about if you're in dispute, who's going to pay the fees. Fees for the title exam, survey, and so forth are usually paid by the buyer. Recording and transfer taxes are in a separate addendum. There is a broker's fee that's paid. Usually, my fee is paid by the seller. So this is authorizing the settlement attorney to distribute the fees to the various brokers. There is also a flat fee of $300 that's usually paid by the buyer to Keller Williams. There may be prorated charges for water or sewer and so forth. These are also worked out by the settlement company, and often if they're paid at the beginning of the month and we're settling in the middle of the month, then the buyer will reimburse for the portion of the month that the seller paid for that the seller is not using after settlement. And then this covers disputes. If there are disputes, usually they go to arbitration. it can go to the real estate commission, and there's that thing, and this covers the legal expenses of each party. Performance, the contract performance is dependent on the delivery of the property and delivery of money, right? Seller agrees to keep existing mortgage free of default. If any party defaults on the contract, then this covers that. What happens to the earnest money and various other parts of the deal. Buyer and seller should read this. Again, this states that I am merely a real estate agent. I am not a legal advisor. I am not a tax accountant. I'm not any of those other things. And the property condition, again, I'm not an expert on any of these things. So I always advise my clients to hire a home inspector who can give that information. If you want a mold inspection or any others, we can do that as well. Any contract for the sale of property must be in writing to be enforceable. Mortgage rates can change. Buyer's opportunity to select the lender. We again here acknowledge that the broker is solely a real estate agent. Property taxes, this is important. You are advised that property tax bill could substantially increase following settlement. So this is because in many cases, the increase in the property tax is limited as the homeowner has the homestead exemption. If they've been there for 20 years, the tax that they're paying is actually well below what the tax for the neighborhood should be. So the sale is going to trigger a revaluation, and the new tax will be at the new property price. From then on, you as a homestead owner have a limit on, a limit on the increase. You are required to get property insurance by most lenders. The seller should consult an insurance minimum maintaining and terminating insurance coverage. So the seller is required to keep insurance until settlement as well. There is also title insurance. Your lender is going to require you to buy title insurance, and then the buyer has the option to buy title insurance. I always recommend it, and I encourage my clients to talk to the title company and get an explanation of what this covers and why you would want to cover it or not, and so on. If you're a foreign investor, here's what covers that. The definitions of terms in the contract. Delivery. So this contract is fully ratified and executable once it has been signed and delivered. So each party has to deliver it to the other. And then here you are, you sign it and initial it. The next piece of the contract is the addendum of clauses. Again, we've got buyer and seller information here and address. If we're asking the seller for a credit, then we check this off. How much is the seller going to give back to you at settlement? If we're doing an inspection after we're under contract, then here's where we check this off. The number of days we're asking to be able to do that, to look at the report and respond back to the seller. And then do we want the right to negotiate and ask the seller for repairs or a credit or something like that? Or maybe we're just doing right to cancel, like we're either going to buy it or not. We could potentially also add some as-is conditions here. We could remove various things like to make it more attractive for the seller. Maybe it's an estate and we are going to say, okay, he doesn't have to be free of trash and debris. We'll take care of that or whatever, right? So these are things that could be done. They're not necessarily always done. You could get a radon inspection or not. Now in Montgomery County, radon inspection is required. If we don't check this, then the seller has to do it and pay for it and send it to you. If you are getting a conventional loan, and we want to check this box because we have an appraisal contingency and gives a number of days, and this is the process for how to negotiate through an appraisal that comes in low. If the real estate broker is going to be holding the check, then we check this, but we're not. We're sending it to the title agent. This is if I am related to some party in the deal, then I need to represent that. And additionally here, if there's anything else, we put that here. I always add that the seller agrees to provide a copy of the owner's title insurance policy for reissue discount, so that my buyers, should they choose to buy the owner's title insurance, can get a discount because they are reissuing from the sellers. If there's a private well and septic, then there's a separate addendum, and we sign there. Now, most often we're doing a conventional financing addendum. So here is that addendum, and again, we've got buyer and seller information here. We're specifying the first trust and the number of days that we're going to take to get that. And then here's where we put some general conditions, like the percentage of the sales price, the percentage of interest. So we want to put a number that's a little higher than what you're expecting, because rates do change between now and maybe when you were under contract. But if it goes way above that, then this gives us an out, right? And the same with the second trust. And then it's contingent upon your ability to obtain the specified financing. So again, if the financing changes, then you are not able to obtain the specified financing, and we have an out. Alternate financing, this shall not apply to any alternate financing. The buyer's election may apply for alternate financing, but may not be limited. And then if this happens, you then have to go to the seller and get permission to change that financing. The seller does have the option to void the contract a certain number of days after the ratification if you do not receive a conditional commitment for financing. So usually we put 21 days here so that we've got some time for your lender to go through underwriting and do everything. The conditional commitment shall include conditions. They basically have done all of their homework, and it shall not contain any conditions for the verification of income, assets, and so forth. And then upon delivery of the conditional commitment, the finance contingency will continue, and seller may no longer deliver notice declaring the contract void under the finance contingency until the settlement date has passed. So this is a key protection for you as the buyer. If settlement does not occur on or before settlement date and the finance contingency has not been removed, the buyer is not in default. Okay. Removal of contingency. The buyer removes the contingency but fails to complete settlement by settlement date for any reason not permitted by this contract. Then the seller could be in default. So that covers that. Finance rejection. The buyer may deliver notice declaring void, the contract void, if the buyer receives a written rejection. Appraisal. In the event the specified contract is declined based upon appraisal, the buyer again will not be in default. And then here's some specific reasons where you could be in default. Settlement or lease of other property, the lender required repairs. So if a condition of financing is that the lender requires certain repairs to be made, the buyer will deliver notice to the seller of those required repairs, and the seller agrees to make those repairs.